Good afternoon and welcome back to the conference. I hope that I'm looking at the colleagues of the Fondazione Basso. I think we can start the afternoon panel and I see the colleagues nodding. So welcome you back to the conference after the fantastic lunch in the garden of this hotel. We are going to tackle a technical but very important issue for the functioning of the European Public Prosecutor, its material scope of competence. And we will investigate in this panel how the PIF, the PIF directive, so to say, the directive on the protection of the financial interest of the European Union, is implemented and impacts the competence and the investigations of the EPPO. We have four excellent experts on this panel that I will introduce to you, as well as how we will proceed during this afternoon panel. We have 2 hours, which is a rather long time frame for a panel. We will try to make it interactive for you a little bit. We will start, let's say, with the policymakers in the panel, if I may put it that way. And we will start first with Fabio Giuffrida, who is Policy Officer at DG Justice at the Substantive Criminal Law Unit. He has been working a lot on the PIF directive, and he will give us first a general overview of the crimes as defined in the directive and the national implementations, at least what the Commission already knows about the national implementation and the challenges of the national implementations of this directive. With this, we will set the scene for the discussion of this afternoon panel. There are many interesting issues in relation to this directive and to the EPPO. One of the hot debated questions has been from the beginning whether the EPPO should have exclusive competence to investigate these offenses. And we know from the regulation that the EPPO has no exclusive competence. And this is the topic that my dear colleague Lorenzo Salazar, as a second speaker on this panel, will highlight to us. Lorenzo Salazar is the Deputy Attorney General at the Court of Appeals of Naples, but he has a very, very long history of looking into matters of the EPPO. He led the working group on the EPPO during the Italian presidency and has negotiated for Italy the EPPO along several years. Following his presentation, we will continue actually with one of the national implementing legislations and the national challenges that we see in the national implementing legislation. And the third speaker on this panel will be Professor Rosaria Sicurella, Professor of Criminal Law at the University of Catania, who will show us what are the challenges for Italian criminal law when dealing with PIF offenses. And we will conclude this panel with Professor Francesca Ruggeri, Professor of Criminal Procedure for the University of Insubria. She will tell us what the material scope of competence means for the defense and the prosecutor to some extent, how the defense can challenge the competence and the jurisdiction of the EPPO. So you will see we will take a rather complete panorama around the PIF directive. We have 2 hours for that. I will ask each of the speakers on this panel to limit their speech to 20 to 25 minutes so that after each speaker, we will have the time within the panel to have a short sort of initial reflection, not yet start the discussion because we will have a coffee break and time for discussion after that, but just to be a bit more lively and interactive for you. With this and without much further ado, I would like to hand over the floor to Mr. Fabio Giuffrida.
Yes, so thank you very much, Katalin. Well, good afternoon to all of you. And first of all, many thanks to Fondazione Basso for organizing this event, and many thanks for the invitation, and especially many thanks to Serafina and their team for the wonderful organization of this event. So indeed, as Katalin said, my presentation will aim to set the scene of the debate, and I will try to discuss 4 points with you. The first one being how to use the remote control. Okay, super. So the 4 points I will, well, first of all, no, it's okay. So I will firstly give an introduction of the directive and the issues that we will be discussing together. Secondly, we will look into the main provisions of what we will call the PIF directive. PIF meaning Protection des intérêts financiers, so protection of financial interests, which is Directive 2017-1371. Then we will discuss the state of play of its transposition in the member states according to the report by the Commission that was just published at the beginning of September. And then we will briefly discuss the impact on the competence of the European Public Prosecutor's Office, or the EPPO. By way of introduction, I would only like to make 3 main remarks. The first one being that the PIF directive has been adopted in 2017, but it is not the first instrument dealing with the protection of financial interests of the European Union by criminal law. Because before the PIF directive, already back in 1995, a convention was adopted on exactly the same topic, and then 2 protocols followed. The reason why I'm mentioning this is not just for, let's say, the sake of archaeology of law, but also because this has an impact on the implementation of the directive, meaning that, as we will see, most member states already complied with the PIF convention. So overall, the efforts by the member states in transposing the directive was not too much, so to say, although, as we will see, there are still some gaps. The second issue I want to mention is that the PIF directive is, so to say, a special instrument which is based on an ordinary legal basis. The speciality, so to say, of the PIF directive is that it concerns the protection of a quintessentially European legal interest. I think it was said already this morning by Professor Parisi, it is their only real European legal good. So it's, I would say, qualitatively different from other EU criminal law instruments. But that said, it is based on an ordinary legal basis, meaning the ordinary legal basis of the European Union for the exercise of criminal law powers, which is Article 83, paragraph 2. It is true that in the treaties there is another legal basis which concerns specifically the protection of the financial interest of the European Union, which is Article 3 to 5 of the Treaty on the Functioning of the European Union. But in the course of the negotiations, this has been changed, and the legal basis is now Article 83, paragraph 2. One consequence of this being the fact that Denmark does not participate in the directive, because Denmark enjoys a special opt-out position from the measures of EU criminal law. Ireland decided instead to opt in the PIF directive. So we have 26 member states participating, or, well, being bound by the directive. The third remark is that the directive, compared to the PIF convention, includes some, of course, new elements. One of them being a comprehensive definition of union's financial interest, which is based and largely inspired by the definition in the 2013 OLAF regulation. And as you can see on the slide, it is indeed a rather comprehensive definition, because it encompasses revenues, expenditure, and assets covered by, acquired through, or due to the EU budget of institutions, bodies, offices, and agencies, as well as budgets managed and monitored by them. So against this background, I think we can now look a bit more into the details of the PIF directive. I would say that as any EU criminal law directive, the main provisions of the PIF directive concern the criminal law definitions, the criminal sanctions, the liability of legal persons, and the rules on jurisdiction. And there are also other rules which we'll probably briefly touch upon. Starting with the criminal offenses, first of all, the directive only covers intentional conduct, so it does not cover, for example, conduct that is committed by gross negligence. That said, the main conduct or the main criminal offense covered by the directive, so the criminal offense definition of which is harmonized by the PIF directive, is fraud. Fraud to the budget of the European Union covers both sides of the European Union budget. So it covers both the expenditure of the European Union and the revenues of the European Union. In turn, the directive then makes a further distinction between procurement-related expenditure and non-procurement-related expenditure on the one hand. On the other hand, it makes a distinction between revenue that is related with a VAT, so value added tax, and revenue that is not related to VAT. I will not have the time to go into the details, but just for you to remember that the definition of the PIF directive on VAT fraud is a bit different than the other definition, because the agreement that was eventually found in the Council and during the negotiations is that VAT fraud is covered by the PIF directive only as long as it is cross-border, so only as long as it covers at least 2 member states, and when the total damage, so the damage to both the budget of the European Union and the member states' budget, is at least 10 million euro. The precise definition of fraud is then to be found in Article 3 of the PIF directive, and in line with the PIF Convention, the conduct is actually based, or the criminal offense of fraud is actually divided into 3 different conducts, being the use or presentation of false documents or statements with a negative impact on the budget of the European Union, the non-disclosure of information in violation of a specific obligation, and the misapplication of funds that are given by the European Union or benefit in the case of revenue. The second crime that is covered by the PIF directive, because the PIF directive does not only cover the crime of fraud, but it also covers other crimes affecting the financial interest of the European Union in Article 4 of the directive. The first one is corruption, so both active and passive corruption. And there, one of, probably the most important, if not the only difference compared to the previous legal framework, is the fact that the definition of corruption in the PIF directive does not require the element of the breach of duties, which was instead provided for by previous legislation. To add on corruption, of course, the crime of corruption involves a public official, and that's the reason why the PIF directive in Article 4, paragraph 4, also provides for a definition of public official, which is a quite comprehensive definition because it covers national officials, it covers union officials, and it also covers officials of international organizations and third countries. The other crime that has been introduced, or it is harmonized by the directive and has also been introduced by the directive, is the crime of misappropriation. The crime of misappropriation is the only crime that was not provided for by the previous acquis in the PIF area. And the definition is found in Article 4, paragraph 3, which defines misappropriation as the action of a public official who is entrusted with the management of EU funds and appropriates or uses these assets contrary to the purpose for which these funds were intended to be used, in a way that damages the financial interests of the European Union. Of course, also for the crime of misappropriation, the definition of public official is the same of corruption. And then last but not least, the fourth crime is money laundering. The choice that has been made in the PIF directive with regard to money laundering is not to define money laundering in the directive as such, but to make a reference to the 2015 anti-money laundering directive. And of course, money laundering as misappropriation and corruption is only covered by the PIF directive as long as it affects or can affect the budget of the European Union. So not money laundering in general. Moving on to the the penalties provided for by the directive. With regard to the natural persons, the directive provides that the penalty of imprisonment should be introduced, and the penalty of imprisonment should be of at least 4 years when considerable damage or advantage is involved, and the threshold is 100,000 euros for that. In addition to that, the directive also provides for an aggravating circumstance. So the member states are obliged to consider, to introduce an aggravating circumstance when the PIF crime is committed in the framework of a criminal organization as defined in the framework decision of 2008. The third block of provisions I wanted to discuss is the one concerning the liability of legal persons. As you know, as any other directive of the European Union in the field of criminal law, the liability of legal persons is not labeled, is not considered, is not required to be criminal liability of the legal person. So the directive only speaks of liability of legal persons, and then it depends on whether the member states have or not a regime of criminal liability for the legal persons. And here, again, the PIF directive replicates the usual scheme of EU directives when it comes to liability of legal persons, meaning that we have the liability of persons in a leading position, but also liability of the legal person when the crime is committed by a person under the responsibility of a person in a leading position, when the crime was possible due to the lack of supervision by the person in a leading position. And then last but not, and of course, just forgot to say the penalties for legal persons are criminal or non-criminal fines according to the member state. And then there is a list of possible penalties that can also be introduced in the member states. And then last but not least, jurisdiction. So there are also some rules on the jurisdiction that member states are obliged to introduce on PIF offenses. And there are two mandatory grounds for jurisdiction. So those that are based on the principle of territoriality. So the member states shall establish jurisdiction on PIF crimes committed in their territory, or when the person who committed the crime is one of their citizens. And then the directive also gives the possibility to the member states to provide for optional grounds of jurisdiction. So in those cases where the PIF crime is committed abroad and it is committed by a person, for example, having the habitual residence in the member state. So these are the main provisions of the PIF directive. Of course, I left as a sort of dulcis in fundo the real new introduction of the PIF directive, which is the provision on limitation period, what is also called sometimes a statute of limitation or a prescription with a French word. So the PIF directive is the first instrument of the European Union that sets out some rules on the limitation periods of crimes. So the PIF directive provides that in case the PIF crimes are punished with the penalty of imprisonment of at least 4 years, in this case, they should not become time barred before 5 years from the commission of the crimes. And in any case, there is also a provision on the limitation period concerning the penalties. So also the enforcement of the penalties is regulated by the PIF directive. And also in this case, so also for serious crimes, the limitation period is 5 years from the date of the final conviction. Then there are a number of other provisions in the directive, such as on freezing and confiscation, cooperation at the EU level, and reporting obligation. I will not go into the details of that. I thought it was maybe interesting to say what is not included in the PIF directive, just maybe as food for thought and in pro futuro perspective. So first of all, there are no provision on minimum imprisonment sanctions. The Commission in the original 2012 proposal had suggested to introduce some minimum sanctions, but during the negotiations, this was discarded. So still, also the PIF directive, like all the other EU directives, does not include minimum imprisonment sanctions. So the usual rule is still maximum imprisonment of at least X, in this case 4 years, but there is no minimum imprisonment sanction required by the member states, arguably because the situation is so different across the member states that it was not possible to find common ground. Another issue which you don't see in the slide is the issue of penalties different from imprisonment for natural persons. So far, all EU directives only obliges the member states to introduce imprisonment sanctions for natural persons, but there are no, for example, obligation to introduce, let's say, financial criminal sanctions. One reason could be that the crimes are so serious that they only require imprisonment, but it might be discussed whether in the future this is something on which harmonization can also take place, especially when, like in the PIF case, but also in the money laundering case, we discuss about financial crimes. So this is perhaps something that might be explored in the future. And this was actually introduced at some point in the text of the directive on the fight against money laundering by means of criminal law. But at the end of the day, it was taken out by the directive and just put in another recital of the 2008 directive. So that said, where do we stand now in terms of transposition of the PIF directive in the member states? The Commission carried out its evaluation on the transposition of the directive in the member states, and on 6th of September, it published the report on the implementation. You will find the number on the slide, so it's communication number 536. So the first thing I wanted to mention is that by the original deadline for transposition, which was July 2019, a bit less than a half of the member states had notified transposition of the directive. So the member state, the Commission opened infringement proceedings against the member states for non-communication of the transposition measures. But in the following 2 years, all member states have notified full transposition of the directive. So by April of this year, all member states have notified full transposition, and at this stage, there are no ongoing infringement proceedings for non-communication. The outcome of the evaluation by the Commission is that the largest number of non-conformity issues that have been found in the member states concern the definition of fraud and other PIF offenses, so money laundering, corruption, and misappropriation, as well as the definition of public official. Let's say that overall, all the member states seem compliant with the directive, but when looking into the details, we saw there are some gaps in almost each member state. So just to give you an example of some of the issues that we have found in the member states, some of the main issues that we have found. So for example, the directive requires in Article 3 to criminalize the use of presentation of false, incorrect, incomplete statements or documents, and this has been interpreted as only referring to written documents in some of member states. Then another issue that has been found is that the directive requires to criminalize non-disclosure of information in violation of a specific obligation, and this is not covered in all member states. So this specific conduct seems to be missing in some of the member states. Another issue that we found is that in some cases, some member states have opted for a narrow wording compared to the wording of the directive. As we saw at the beginning, the definition of financial interest of the European Union is quite comprehensive, but sometimes this, let's say, this definition is not really mirrored in the legislation of the member states, because some kind of, for example, funds of the European Union are not covered by national legislation. Another issue that we found in a few member states concern the crime of money laundering, because not all the PIF offenses that are harmonized by the directive are included among the predicate offenses for money laundering. And another issue that we found is that in some member states, the requirement of breach of duties is still required for the offenses of corruption, which arguably narrows down the scope of the criminal offenses. And this is the reason why the PIF directive does not require for this element in the definition. And then the other issue that came up quite frequently is the issue of the public officials, because the wide or broad definition of the directive is not always mirrored in the member states, because we found that, for example, national official of other member states compared to the member states concerned, or officials of third countries, are not included in the definition of public official. Other issue that we found, but maybe I will just go quickly through them, it's that the well, in some cases, for example, with regard to the liability of legal person, in some cases, the liability of the legal person is dependent on a final conviction of the natural person. And this is not compliant with the directive, because paragraph 3 of Article 6 clearly says that the two liabilities should be independent. So the liability of the legal person should not be made dependent on the liability of the natural person. In some cases, the threshold of penalties are not met. And then in the other issues that we found, which are not really issue of non-compliance, but it's just to explain where we stand, about a half of the member states have decided to extend the jurisdiction on the basis of the optional grounds. So far, on the basis of our assessment, of course, an assessment that is based on the law in the books, so to say, so no the law in action, but on the text of the national legislation, we didn't find any issue concerning limitation period of crimes. We did find some issue concerning limitation period of enforcement of penalties. If I have 5 more minutes, I will talk about the impact on the EPPO competence, and then I will wrap up my presentation. The PIF directive is, of course, of crucial importance for the EPPO, because the material competence of the EPPO is defined by means of reference to the crimes that are provided for, that are harmonized by the PIF directive. So Article 22 of the regulation says that the EPPO is competent for the crimes provided for in the PIF directive as implemented by the member states. There is only one, let's say, peculiarity in the EPPO regulation, that is the fact that the requirements of the VAT fraud, so the requirements that we discussed before, VAT fraud being cross-border and having a total damage of at least 10 million euros, these requirements are set out in the regulation, which is the only case in which the regulation decided to copy or to replicate the text of the directive, which also means, among other things, that if the directive, the PIF directive, is changed in the future, and for example, the threshold is lowered, then the threshold for the competence of the EPPO will not change, because that threshold is only set out in the, well, is also set out in the EPPO regulation. Of course, the impact of the PIF directive on the competence of the EPPO, I would say it's inherent in the nature of the PIF directive as a directive, whereas the EPPO regulation has been created and established by means of a regulation. Meaning that, of course, the directive is only binding with regard to the results, but then it is for the member states to implement the directive. So this means that, first of all, there might be cases in which the national legislation is not compliant with the PIF directive. So this can have, in turn, an impact on the competence of the EPPO, meaning that the competence of the EPPO is not as broad as provided for by the PIF directive in those member states where the PIF directive has not been correctly implemented. So this can be an obstacle for the EPPO. And of course, the other issue is not only within each member state, but also but also across member states. It is somehow in rerum natura, I would say, in the nature of things, that the definitions of the crimes for which a single body of the European Union is competent are different across the member states, because the directive has to be implemented in each member states. Whether this will create problems in practice, of course, we are curious to hear this from the PPO, and we will see whether as the English would say, the proof of the pudding is in the eating. So this case is in investigating. So we will see whether this creates problem, but of course, by definition, the directive cannot have the same level of harmonization of regulation. I just want to make two quick remarks before wrapping up my presentation. Well, the first one is that we always say that the EPPO is competent for PIF crimes, but that's not entirely true, or let's say not 100% true, because the EPPO is also competent for crimes that are not provided for by the directive. So first of all, the EPPO is also competent for organized crime. Of course, whenever the focus of the activity of the criminal organization is the commission of PIF crimes. And in second place, the EPPO is also competent for what are called inextricably linked offenses. So offenses that are inextricably linked to the PIF crimes. So, for example, one may think of falsification of documents, which is indeed a precondition for the commission, for example, of fraud. There are some conditions under which the EPPO can exercise the competence on inextricably linked offenses, but I will not have the time to discuss them, but they can be found in Article 25 of the EPPO regulation. And then last but not least, there is some also, I would say, degree of consistency between the PIF directive and the EPPO regulation when it comes to the damage of the crimes, of the PIF crimes, meaning that the PIF directive provides that for crimes where the damage is below 10,000 euros, the member states can also introduce, can also decide not to have a criminal law regime. And somehow this is, well, is not mirrored, but it is also a fact that the EPPO is not in principle competent for crimes for which the damage of which is below 10,000 euros, although there are some exceptions, such as, for example, when the case involves a European Union official or it has repercussions on the European Union. And then we have also seen that the threshold of seriousness in the PIF directive is 100,000 euro, meaning that this is the threshold for which the PIF crimes should be punished with a penalty of at least 4 years of imprisonment. And this is also the same threshold of cases below which the EPPO may decide not to exercise its power to evoke, to take over the case from national authorities, or to be more precise, when the damage is less than 100,000 euros, the college can issue guidelines on the non-evocation of the cases by national authorities, or non-evocation of cases by national authorities, non-evocation by the EPPO, of course. So the college has already published these guidelines this year on when the EPPO should not evoke a case when the damage is less than 100,000 euros. So to conclude, the PIF directive is a key instrument of EU criminal law, and I would say it is so per se and in its connection with the EPPO. Per se also because we don't have to forget, we have to bear in mind that not all member states participate at this stage in the EPPO. We have some of them which do not participate, and those are still bound by the PIF directive, of course, with the exception of Denmark, as we said. And then, of course, the PIF directive is key in its connection with the EPPO because it draws the boundaries of the EPPO competence. Indeed, I just want to repeat what I said before in terms of where we stand on the state of play of the transposition in the member states. So while all member states have notified full transposition, a closer examination revealed that there are potential non-conformity issues in almost all member states. So we will see how to proceed in that respect. And of course, as always, the last word on the non-conformity with EU law lies not with the Commission, but with the Court of Justice of the European Union. And then on the way ahead, just to inform you that the Commission is obliged to produce 2 more reports on the PIF directive. One is supposed to be published next year, and it is about whether the BAT threshold is effective, whether the limitation periods, the rules on the limitation period are sufficiently effective, and whether there is a need to review the rules on procurement fraud. And by 2024, we are instead supposed to make an even more comprehensive report on the impact of national transposition laws on the prevention of fraud to the European Union's financial interests. So I would stop here and apologize if I spoke too much. And thank you again for your attention. Thank you.
Thank you very much, Fabio, for this excellent and comprehensive overview of the main provisions, the implementation, and the impact of the PIF directive for the EPPO. Before we move to the second presentation, I want to ask my members, my panel members, if they would like to initially react quickly to anything. No?
And the first round. Maybe we can
Yeah.
save this for the second round.
Okay, then we move right on to the next presentation on the non-exclusive competence of the EPPO, and I give the floor to Lorenzo Salazar.
Grazie, Katalin. I will speak in Italian, being for once in my own country. So I leave you the time for wearing the earphones. Come è stato già detto da Katalin, mi concentrerò su un aspetto particolare relativo
legislation or the higher level of European level. And then, for instance, the investigative powers and investigations, cross-border investigations, and various forms of criminal action, and the question of burden and transactions. So I've given you a very sketchy picture of the situation. Once again, just to give you an idea of the level of complexity that we have to deal with. EPO has been up and running for a number of months now, so they have been confronted with this level of complexity, and they have achieved already number of results. And then we have the articles of the regulation which refer to the directives of the Union transposed in national legislation. This is the protection of the right of suspects and part of the minimum rights for trials. And then we have Article 22, which refers, in terms of the material competence of EPO, refers to the Directive for the Protection of Financial Interests in terms of substantive material competence. We know that the Directive came into being under a sort of a difficult situation. The article which was the basis for the creation of that was Article 25, but then the legal basis was Article 83 with limited harmonization, as Article 83.2 was confined to minimum rules, had somehow reduced the weight of the directive and reduced the ambitions which originally were expressed vis-à-vis the directive. So unlike what happened in the first decade of this century, the Commission did not dare to go to the Court of Justice on this matter, even though at the time when the directive was adopted, one member state abstained because of the question concerning the legal basis, and it was Italy that abstained, in that it was not in agreement with the legal basis agreed by all other member states. It's not the directive to be blamed for the current problems. The problem is that EPPO doesn't have sort of exclusive competence on all the crimes and offenses envisaged. The initial approach of the original proposal of the Commission assigned to EPPO the competence and the jurisdiction to all PIF crimes and offenses which affect the financial interest, as set out in the PIF directive transposed in national legislation. And the Article 13 envisaged further competence for ancillary crimes, which were inextricably connected to the PIF crimes. All other offenses were within the remit of EPPO. Well, but what Fabio told us is the end result of the negotiating process. We have mixed competence, which in many instances does not enable EPPO to exercise its own competence. In other cases, it envisages a sort of tug of war between the EPPO and the national legislation. So the national link and the attempt to ensure that the national level could be involved, which characterized the negotiation on the part of many states to ensure that they would keep for themselves the competence of EPPO, and as they fear there would be too extensive level of competence, resulted into the following situation. In the current situation, also, as you are all aware, on many occasions that happened in Brussels when there was a need to come to compromises. So we managed to obtain a final result, but we have somewhat reduced our ambitions. And well, there is a danger that there's a kind of flaw has been introduced in this regulation, which might sort of produce its impact later on. What was in the original proposal, the exception of the ancillary competence, which was the only exception to EPPO competence on PIF crimes, is now extended to the exercise of such competence and has and thus increasing considerably the possible conflicts. Not only do we have the definition of inextricably linked for the ancillary crimes, we have problems with respect to organized crime, and the fact that we have to determine EPPO competence on criminal organization whose activity is focused on PIF crimes. We have the criteria of the value of the damage, 10,000 euro for EPPO to exercise its competence. And we have general directives which allow for national competence and jurisdiction below 100,000 euro. We have the possibility of financial damages lower than that of other cases. We have a penalty which is less severe than the ancillary crime. We have a series of loopholes in a way that are all sort of designed to bring towards back to the national level the competence that was supposed to be granted to EPPO. And then we have conflict of competence. The initial proposal put forward by the Commission basically resolved in terms of the ancillary competence of EPPO. There wasn't any conflict of competence in the initial proposal of the Commission when it comes to the competence on PIF crimes. There could only be competence on the ancillary crimes. Article 13 of the original proposal of the committee read as follows: conflict of competence in terms of the ancillary competence, but it couldn't be any conflict of competence on the protection of financial interest crimes. We now have a very high level of possible conflicts. If you refer to the national authorities which are competent in the member states, with a possibility of 22 different case laws for the settlement of these conflicts of competence. And that is why during the negotiation, as soon as this possibility arose, I must say that the Italian presidency had the strength to respond to this attempt at creating an imbalance with respect to the initial proposal put forward by the Commission. In some cases, we won. And one such case was that the possibility of taking up to the Court of Justice in Luxembourg all the conflicts of competence which could not be settled, because initially there was a proposal which was envisaging every competence on the part of the national authorities. Well, during the negotiation, however, there were all sorts of possible additional conflicts that might arise in connection with PIF crimes. That's why we say, well, beware, we're going to have 22 different case laws. So let's make sure that they play a role so that the national authorities, which are competent to solve the conflicts, can send to the court the request. Initially, this was not in the Commission proposal, but in Article 42, we wrote that one could go to the court for conflicts of competence that can be raised before the national authorities.
Qui stiamo operando, passatemi ancora una volta l'espressione un po' come una deroga alla deroga. Perché? Perché il principio generale è che gli atti delle istituzioni o degli organi dell'Unione appartenga alla Corte di Giustizia. Grazie a quanto c'è scritto nell'articolo 86 del Trattato.
Court of Justice, thanks to Article 85 of the treaty, we have a derogation to this principle where we have national authorities having competence over the resolution of conflicts. And by derogating to this derogation, we managed to achieve a balance where the court should receive not an excessive number of questions related to this conflicts of competence. I would say that you are all familiar with this mechanism, but in case there's a conflict between EPPO and National Prosecution Services on whether a criminal association is mainly directed at committing PIF crimes, or whether the value of the damage amounts to X or Y. Well, this competence issue in the first hands should be resolved to the authorities indicated by the member states, but these authorities can send the matter to the court. For example, the issue of interpreting a certain notion on what the main activity or the main focus of a given criminal organization is, and so far and so forth. In relation to this, also the matter emerged, and I know that on this point with Fabio, we don't have the same opinion. The matter emerged on whether the regulation says that it is the member states that have to say which are the national competent authorities, and when, in cases when member states have entrusted the resolution of some conflicts to national authorities that may, for example, belong to the branch of prosecution rather than to others, then there is a further competence problem in terms of taking the matter to the court, because we know that the court normally requires jurisdiction. But on this point, I would observe the following. Number one, national judiciary authorities, that was in the original formulation, the judiciary was dropped in the final formulation, and also the fact that the intent of the regulation is quite clear, and particularly Article 11. And this means that member states can choose which are the competent authorities entrusted with the resolution of conflicts of competence. And so the useful effect of this norm cannot be preserved can only be preserved by establishing that those competent authorities can take the matter to the court, because otherwise, on the one hand, we lose all useful effects of the provision, and on the other, we risk having states when you have a situation where the national authority can take the matter to the court, whereas other member states would not have such possibility. And this, of course, would not be possible. I will stop here with the more sort of technical comments, hoping that you managed to follow me in this, and I will try to go to the conclusions. As law experts, we are passionate about any detail, but of course, the aim is for this new instrument to function well, effectively, and hopefully not burdening the Court of Justice with an excessive number of cases taken to the court. So a number of cases sufficient to sort out the matter, but not so high to create bottlenecks. The point, once again, is that there was a desire by some to have a very intergovernmental approach to the negotiation, and this has created has left empty room. But we have enough authority, and in particular, the European prosecutors have all the tools so that they can cooperate with the national authorities. And I believe that this cooperation effort will actually prevent the risk of conflicts of competence rather than harshen them, hoping that in cases when the conflicts emerge, the matter is taken to the Court of Justice. And when back in the 1980s, I used to, when I was working at the Court of Justice, we used to call it the réflexe communautaire. And I hope that this will continue playing a role. And I'm also convinced that the court will successfully guide jurisprudence so that this new tool can achieve its purposes. Thank you very much.
Thank you very much, Lorenzo, for this thought-provoking intervention. I already looked at Fabio, whether he wants to comment on this, but I think we will first move to look at the national perspective and the Italian legislation. And if we have time, we come back to some initial reflections. So I hand over the floor to Professor Rosaria Sicurella.
Thank you, President. Grazie, Katalin.
Thank you, Katalin. The choice to give you an insight on where we stand in terms of transposition of the PIF directive in Italy, in my view, gives us an opportunity of considering the most important traits of choices made by the Italian lawmaker. And then during the discussion, we can discuss about that, of course. But basically, the purpose of this presentation is to try and sort of pinpoint some of the difficulties of this law concerning the transposition of the PIF directive. Not just difficulties which are basically due to problems with the drafting of the transposition law, but also difficulties which might be a clear indication of the weak points which we find in directive. In other words, the choice of the directive as an instrument which provides considerable leeway to the member states and therefore opens up a series of possible differences and heterogeneous positions which can only have a sort of a negative impact on the effective role of the EPPO. Italy has implemented the PIF directive after an enabling law with 1 year later than the deadline set out in the directive. The Commission has written to Italy for failure to notify implementing instruments. It wasn't just Italy that did that, but other 14 countries failed to do that. But if you read the decree, you immediately notice an approach by Italian lawmaker which confirms what's in the directive. So the decree, the enabling law, refers to legislative positions which pre-existed, and it doesn't really try to deal a more broad-based reform, which have been sort of advocated for a long time for the protection of financial interest. So to try and sort of rationalize the various categories of crimes and the rules to combat frauds and acts which sort of affect the financial interest, which is just the contrary of what happened in Germany, where they have taken the PIF directive as an opportunity to sort of ensure that it would be a more focused approach to the protection of financial interests. Now, the definition of the various PIF crimes and offenses will transposed at national level could have been a solution, more appropriate and far-sighted approach vis-a-vis the EPPO, because it would sort of include in one text the reference laws and the law applicable by the EPPO when it comes to Italian legislation. But if you read the report of the enabling law, you see this possible reasons for the Italian lawmaker to sort of not go beyond what was in the national legislation. It's as if the Italian lawmaker was afraid he would encroach on an area which wasn't covered by the enabling law. Well, in the report, it says that we would have, if the lawmaker had gone ahead differently, well, it would have encroached on the series of substantive rules of a penal nature. Well, this rather limited impact of the implementing law adopted by Italy, it's a clear reflection of the limited sort of choice that was made. It was a clear choice made at the European level from changing the legal basis from Article 25 and shifting to Article 83 as a legal basis for the directive. In Article 325, we have all the reference to minimum rules, which are set out in Article 83, as Lorenzo Salazar said. Well, during the debate on the directive, a series of formal words concerning the possible offenses and crimes have been somewhat played down or reduced. On some occasions, some of these definitions were not appropriate, but definitely in the end, there was a sort of a more limited ambition expressed by the lawmakers, and the choice of Article 83 represents a major hindrance to a possible reform of the PIF directive when it comes to institutes of a general nature. Well, Article 83 simply mentions the criminal relevance of specific persons, but it doesn't sort of define the common criteria in terms of the attempt and complicity in committing an offense, referring to national rules. It's quite obvious. This represents a basic limitation with respect to the homogeneous approach of legislation vis-a-vis EPPO. We know that the criminal liability is depending on the description of what is the typical element containing the general rules and other conditions such as the complicity in the act. So it is not possible to limit in the various sort of scope of competence of the EPPO with respect to the PIF offenses contained in the directive. I do not think that Article 83 as such, which talks about minimum rules, excludes the possibility of harmonization on the part of general rules. Well, but the minimum harmonization of criteria which are relevant for general rules as such should be the necessary follow-up to the definition of various categories of crimes, something which would be certainly necessary for the PIF directive that should provide applicable law for the topmost body of investigation at supranational level. That could be sort of a directive which concerns only general rules, institutions, but only sort of with respect to specific cases. But the possible sort of common definition could be recalled in other directives with complicity and attempt at committing such crimes and offenses. Well, this is a fairly optimistic interpretation because at this point in time, well, this rather courageous interpretation of what's a letter of Article 83 is not plausible, really. this idea of the attempt and the complicity of persons who committed a crime has been mentioned because in Italian legislation, there is a reference to this element with respect to the conformity in terms of application. Well, we have to consider the compatibility of Italian legislation with the PIF directive. Is not so much due to the rather open and advanced nature of Italian legislation, but rather the sort of limited extent of the PIF directive has to do with time limitations. What Fabio said, it's clear. It's Article 12 of the directive is something completely new in that for the very first time deals with time limitations. And it takes on a Europe-wide nature in the PIF directive. This is not to be found in other directives when it comes to time limitations, but it does give 5 years for time limitation, slightly less, 3 years. If there are specific interruptions of suspensions, it also envisages 5 years for the sentence. Well, if we take into account the Taricco case, there was a problem, a very strong problem of compatibility of Italian laws with respect to the obligation on the part of the states to protect financial interests. Was not related to the time limitation, but was due to the specific mechanism connected to suspension and interruption of the time limitation. The final text of the directive doesn't refer to that. It talks about suspension and possible interruption, but doesn't sort of deal with mechanism for interruption of the time limit, time barred condition. Whilst, in the Taricco cases showed that in the event of interruption, while the time limitation would start anew, afresh. So that was a conflict with the Italian legislation. The Italian legislation, which was mentioned in the Taricco case, today appears to be in conformity. Well, the increase of the penalty for the fiscal crimes has been extended to 10 years, so we're way beyond 5 years. Well, the approach of the enabling law of 2020 is a targeted act and does not preclude sort of some implications for the whole system. Well, in no sort of legal system, a specific act that doesn't have a sort of a chain effect. Some of these implications haven't been sort of considered sufficiently by the national legislator. And this raises questions about the internal consistency and the effectiveness of the PPO. I'm not going to go into the provisions that have been taken into account, but the law of 2020 acts on in four areas. On the one hand, the criminal code, so it does cover some rules in the criminal code, legislation on fiscal crimes, legislation related to customs, and the very large area of criminal liability, of legal persons, legal entities. And that is the area where the impact has been greater in terms of the implementation of the directive. Let's take a look at the changes of the criminal code, which are the most relevant. Well, basically, there were two ways of changing some provisions in the criminal code. They have sort of strengthened the sanctioning power, and for the more severe forms, which said that there shouldn't be less than 4 years. For instance, considering frauds, fraudulent statement, misappropriation by public officials, with an aggravating circumstances, which would result into a situation where the crime is affecting the financial interest of the European Union and the damage exceeds 100,000 euros. It's all very well that the directive gives advice on the sanctions, at least 4 years, but that's something innovative, but it isn't a proper harmonization, because all studies in terms of harmonizing sanctions indicated that harmonization could not be based on an absolute quantitative parameter. In this case, 4 years does not allow you to translate into a proportionate manner the problem created by the individual crime. So the first step that was taken had to do with the criminal code, with the aggravating circumstances. The second type of action was the extension, subjective extension of some sort of cases. For instance, the Article 640, which did not mention the European Union together with a member state as a possible victim of this crime, but also the criminal liability of third countries, of international organization. This is a very strong step undertaken. We'll see what will mean in terms of implementation. Well, the idea of aggravation of the possible sort of type of offense and crime, it's rather problematic, because you have the problem of coordinating other aggravating circumstances which are already included. There is one that has to do with the general rules on complicity in the commission of the offense, where a sort of aggravating circumstance may not result into actual worsening if there are sort of extenuating circumstances that the judge deems to be prevailing.
Valore rappresentato dalla circostanza aggravante potrebbe non tradursi in nulla poi nella sanzione, nella pena effettivamente irrogata. Per quanto riguarda, diciamo, il secondo comparto, per il momento vado necessariamente in modo veloce, poi eventualmente ritorneremo su singole questioni al momento del dibattito. Il secondo comparto è quello dei reati tributari. Anche qui l'intervento, diciamo, primo acchitto è abbastanza minimale. Ma perché? Ma perché prima della sentenza, prima del decreto legislativo del 2020, in realtà c'era già stata un'importante riforma che aveva elevato, intervenuto su molti aspetti, ma poi soprattutto ha elevato quelli che sono i livelli sanzionatori, e quindi, come vi dicevo prima, si va anche ben oltre il limite previsto dalla direttiva PIF. Perché è interessante però l'intervento in materia di reati tributari? Perché l'obbligo di penalizzazione relativo alle condotte di tentativo ha comportato per il legislatore interno di come dire, intervenire per abrogare, per derogare a quella che è una norma generale che prevede la non punibilità dei fatti di tentativo coperti dalla direttiva. In realtà c'è una serie di dichiarazioni fraudolente o infedeli che appunto erano stati fatti oggetto appunto nella concezione complessiva della legislazione tributaria, non sono rilevanti. Cosa fa quindi il decreto legislativo? Dice che limitatamente ai fatti coperti dalla direttiva, il tentativo, che continua a non essere rilevante per altre vicende che non riguardano gli interessi finanziari dell'Unione, invece è rilevante perché ha dovuto chiaramente rispondere all'obbligo scaturente dalla direttiva. Ovviamente, ecco qui un altro vulnus, a parte il problema di, diciamo, conformità interna, di diverso trattamento di reati tributari secondo che riguardino solo gli interessi dell'Unione e non gli interessi nazionali, ma anche un grosso problema anche rispetto a quello che diceva Lorenzo Salazar, perché dobbiamo pensare che nella fenomenologia criminosa non è che troviamo, come dire, la frode IVA UE in purezza e la frode IVA italiana in purezza, ma molto spesso sono concatenate, cioè fanno parte di una stessa, diciamo, catena criminosa, e quindi capite bene come andare a lavorare a questo punto con rilevanze anche diverse della punibilità diventa particolarmente problematico. La delega, scusate, il decreto legislativo segue appunto la legge delega che aveva sulla base degli obblighi della direttiva chiesta l'abrogazione espressa di qualunque norma generale escludesse la rilevanza del tentativo, diceva anche per il concorso di persone. Qui invece il legislatore delegato dice chiaramente: sul concorso di persone io non recupero la punibilità. Cioè la legge generale prevede che tutta una serie di comportamenti di dichiarazione infedele o fraudolenta non siano puniti nella forma come partecipazione ad un reato, perché sono già puniti come reato autonomo nel nostro sistema, cosa che magari in altri sistemi non c'è. Quindi, come dire, dice la relazione illustrativa, se noi lo andassimo a punire in realtà ci sarebbe un ne bis in idem, cioè noi andremmo a punire lo stesso comportamento come reato autonomo e come partecipazione poi nel fatto successivo che impiega il documento in cui c'è la dichiarazione infedele, fraudolenta e quant'altro. Scelta forse logica nell'ottica italiana, ma che, come dicevo prima, poi nella prassi applicativa andiamo a vedere potrebbe lasciare dei vuoti di tutela. Per quanto riguarda, dico soltanto una battuta, per quanto concerne i reati doganali, e lì pure c'è un segnale importante di impatto delle scelte a livello europeo sulle scelte di politica criminale nazionale, perché anche con il riguardo ai reati doganali e alle figure di contrabbando, la legge delega, seguita ovviamente dal decreto legislativo, cosa deve affermare? Un'eccezione alla depenalizzazione generale realizzata nel 2016 per quanto riguarda tutta una serie di reati puniti soltanto con la pena pecuniaria, tra cui rientravano anche alcune ipotesi di contrabbando, diciamo, coperte adesso appunto dalla direttiva. Quindi si recupera, diciamo, sempre attraverso l'innesto di una circostanza aggravante ad alcune fattispecie di illeciti doganali, in parte diventano reati e si recupera appunto quello che è la rilevanza penale che invece in termini generali era stata esclusa. Anche in questo caso solo laddove siano in gioco gli interessi finanziari dell'Unione. Ecco ancora una volta il problema del trattamento diverso rispetto ad eventuali appunto altre situazioni. Concludo con qualche appunto spunto per quanto riguarda, come dicevo prima, il comparto più significativo, cioè quello più significativo, diciamo, in termini di ricadute di sistema, che è un po' quello che riguarda la responsabilità dal reato delle persone giuridiche. Dico subito che la responsabilità del reato delle persone giuridiche ha un suo riferimento normativo in Italia, la cosiddetta 231, cioè il decreto legislativo 231 del 2001, che, mi sembra interessante notarlo, è stata adottata in attuazione della delega contenuta nella legge 300 del 2000, che era una legge di attuazione della Convenzione PIF e dei protocolli allegati che prevedevano, che richiedevano, il secondo protocollo richiedeva appunto la responsabilità delle persone giuridiche. La scelta fatta dal legislatore del 2001 è una scelta diciamo molto articolata, perché da un lato non definisce la responsabilità penale, una responsabilità amministrativa, ma è una responsabilità da reato, cioè è una responsabilità dell'ente accertata nell'ambito del processo penale, dove si discute, diciamo, della rilevanza penale dei fatti di persone fisiche, dove però la persona fisica può anche poi non risultare identificata, no? Quindi diciamo questo in qualche modo rende indipendente. Qual è l'impatto della direttiva PIF? L'impatto è dovuto al fatto che le persone giuridiche non sono responsabili per tutti i possibili reati realizzati da chi appunto abbia agito in posizione apicale o nel favore, nell'interesse della persona giuridica, ma soltanto per una lista di reati che fino alla direttiva PIF non copriva innanzitutto i reati tributari. Quindi un grande impatto è dovuto all'inserimento nella lista, diciamo, della 231, l'inserimento appunto di tutta una serie di fatti, quindi reati tributari, determinate figure di contrabbando e una serie appunto di figure dei reati dei pubblici agenti. Qual è la conseguenza? Perché dico che è una importante conseguenza di sistema? Ovviamente taccio su tutte le critiche mosse su un rischio di duplicazione della punizione dell'ente inserendo i reati tributari nella lista dei cosiddetti reati presupposto. Però c'è un problema, cioè un impegno di sistema importante, perché la responsabilità degli enti in Italia poggia su un elemento in più rispetto al modello europeo, che come dire, che poggia esclusivamente sul discorso dell'avere agito a vantaggio nell'interesse, perché c'è tutto il meccanismo dei cosiddetti compliance programs, cioè la responsabilità dell'ente entra in gioco quando è inadempiente rispetto ai modelli di comportamento, all'adozione e all'aggiornamento dei modelli organizzativi posti in essere per evitare la realizzazione del reato. È chiaro che nel momento in cui si è andata molto ad arricchire la lista dei reati presupposto, diventa come dire, necessaria la revisione, l'aggiornamento dei modelli organizzativi da cui dipende anche la responsabilità dell'ente, quindi non soltanto dall'elemento del modello europeo della responsabilità delle società, che appunto sono appunto quello dei modelli organizzativi. Ovviamente diciamo, la difficoltà e la coerenza con cui si procederà a tutte queste come dire, modifiche avrà un diciamo, decisivo impatto, come dicevo prima, su quella che poi è l'efficacia dell'EPPO. Mi fermo qui. Grazie.
Thank you very much, Rosaria, for this comprehensive overview of the challenges put by the directive to national implementation. As we are rather running a little bit behind schedule, I will immediately give the floor to Professor Francesco Ruggeri to take a bit more procedural view and look into competence and challenges of competence by defense lawyers.
Grazie, Presidente.
Thank you, Chair. I'd like to thank the Fondazione Basso Before starting from a very specific perspective, that of the lawyer of for the defense, I'd like to share with you some of my sort of experience. I've been sort of discussing at the Fondazione Basso this question of the institution of the European public prosecutor. We now have it. Now, as a criminal lawyer, confronted with this new creature, I'm very impressed. We have studied it, we have worked on it, but today I think the most difficult perspective I'd like to put to your for consideration is that of the lawyer for the defense and the citizen. Like many of you have seen sort of the public prosecutor and beginning of a public prosecutor figure in Europe, but he is the expression of the public power in the penal legislation, but it is part not of a state, but is part of a body. And what is most interesting to us is how the lawyer for the defense and the citizen can control the use of this huge amount of power, which is that of the prosecutor. So I'd like to somewhat talk about a different perspective. One has to do with the guarantees of the jurisdictional body, which hasn't just to do with the intervention of the judge on the prosecution, on the prosecutor, but it's a broader issue that has to do with the application of the law according to foreseeable idea. Well, so the intervention of the judge, which isn't just that of a controller, that guarantees greater independence with respect to the prosecutor, but it's an intervention which might sort of result into the interpretation and the application of some specific themes. This is a very broad-based subject, both in civil law and common law countries. This is something which is considered the judge as a source of law. So, in view of the interpretation of the law on the part of the judge, foreseeable interpretation of the law on the part of the judge. I try to use categories that should be translated into English law, which isn't simple. Well, the second point has to do with the defense lawyer. We don't have to just think in terms of the right of defense to a fair trial as it is organized in the European Court of Human Rights and the Charter of Nice, but has to do with the role of the defense lawyer. Well, in any trial, the defense lawyer is interested in the compliance with the rules, well, more than the judge, because if he is the lawyer for the defense of a person that has been affected by a crime, or if he's defense lawyer of the perpetrator of the crime, he has to consider the proper way of interpreting it. So I think we have to shift the perspective from the public prosecutor, which is the public body, which exercises its strength, to the perspective of the person that is affected by in terms also of being deprived of personal liberty. We have been listening a number of experts that have looked at a different perspective. And we've heard that the regulation goes as far as the beginning of the criminal action, so the beginning of the trial, whatever is being collected during the preliminary phase. Let's say right away that the regulation, also referring to corpus juris, the regulation provides a very strong link between the rules of the European Union and the national legislation. If we talked about the European public prosecutor, we used a slogan and said, we're talking about the European public prosecutor for an action without jurisdiction. But today we're confronted with a regulation which, let's take it to the end, well, somehow breaks up the symmetry, which is a very rigid, strict symmetry between sort of dismissal and action.
In part, we have created a situation where now we have a prosecutor's office, but then lawyers must be able to do their job in practicing the checks and balances in the way this power is exercised.
Thank you very much, Francesca, for showing us also the details and the difficulties once the EPPO is in action. I thanks for the audience, for all the patience, for going through this rather long panel. Now we have a coffee break, and I suggest that we come back at 5 o'clock to continue with the discussion. So as promised, we are coming to the last part of today's conference and start the discussion on the material scope of competence of the EPPO, the implementation of the PIF directive. And we have already heard many inspiring presentations. First, I would like to give the floor to the members of this panel to give some initial reactions and to kick off the debate. And after that, I will give the floor for questions, and I will collect the questions. And I suggest that because of the late hour, we collect the questions, and then each member of the panel can react to the question. So I don't know who would like to start in the panel. Maybe Fabio, on behalf of the Commission. The conflict of competence was already challenged, so I hand over to you. And then I suggest that maybe in the order of the presentations, we can give some initial reflections. So the floor is to you, Fabio.
Yes, so thank you very much, Katalin. Yes, I just wanted to comment on 3 points that have been raised in the previous presentation. The first one being indeed the conflicts of competence, which was touched upon by Lorenzo. I don't want to open here the debate because this is something that we have been discussing and probably will be discussed again in the future, but just to clarify, let's say, the points or the issues in the debate there. So we all want to ensure that the Court of Justice is in a position to give preliminary rulings on the rules of the EPPO regulation concerning the conflicts of competence between the EPPO and the national prosecutors. You spoke of viruses, that would be the vaccine. So we all want that. The issue is, how do we get to the Court of Justice? You gave one reading of the regulation. Probably there is also another reading which I don't know, maybe is not totally agreed upon, but it's that if we want the Court of Justice to be involved in the conflicts of jurisdiction, it should be the authority that is competent to solve the conflicts of competence between EPPO and national prosecutors that can go to the Court of Justice. The problem is that when that authority is not a court or tribunal, but is a prosecutor general, as it usually is the case, or a bodies of prosecutors, it is highly likely that as the case law of the Court of Justice stands, this will not be recognized as a court or tribunal. So the court would most likely declare it inadmissible. Of course, we have to find a way out of this conundrum. Probably the easiest way out, which is of course out of our control anyway, would be for the Court of Justice to develop, or well, better, to interpret the notion of court or tribunal as covering also the cases in which a prosecutor general or a prosecutor, let's say, is called to solve or to decide on a conflict of competence, arguing that all the prerequisites, all the preconditions for that authority to be considered as a court are met. Because in that case, one could argue that the prosecutor general would be acting inter partes, would be solving a dispute. So in that specific exclusive only case could be indeed a court or tribunal allowed to go to the Court of Justice. The problem is, what if the Court of Justice does not change its case law? Would this mean that in those member states where either it is a prosecutor general or there is no possibility to ensure a judicial review of a decision of the prosecutor general, in those two cases, there is no possibility to go to the Court of Justice when there is the conflict of competence, so at the beginning of the investigation, or likely at the beginning of the investigation. So this is the issue that we have to solve. And of course, another way out would be to ensure that the authority that is competent is to solve the conflicts of competence between the EPPO and the national prosecutor is a court or tribunal. And here I just want to mention, but this is also, I mean, thinking ahead, there's been recently a case of the Court of Justice, and it's case C6620, which the Court of Justice said that the prosecutor is not a court or tribunal in a different context, though, which is the context of the European investigation order, because in that case, it's not in any case an inter partes procedure. And there, you could read the judgment and see whether there is any way out for applying that same reasoning to the conflicts of competence in the EPPO regulation. The second point was about Rosaria's reference to whether there could be a directive only regulating, let's say, aspects of general criminal law. I don't think that would be possible. Of course, what we could think in the future is whether new EU criminal law instrument would, for instance, take a step forward, would, for instance, introduce, I don't know, definition of aiding and abetting or attempt. And then this would create an imitation effect, so to say, meaning that if we have one directive doing so, then we could hope, or we could see whether further directives would actually keep that same meaning and perpetuate, so to say, across the different EU instruments. Of course, I have to say that so far this has not worked out well with regard to the statute of limitation, which has been included in the PIF directive, but is not included in the two others EU criminal law directive, in the two other criminal law directives that have been adopted afterwards, the money laundering and the counterfeiting of the euro. We will see whether in new upcoming directives this will be taken up again. And then one last point, which I think it's very interesting, it's the statute of limitation. As I said, so far on paper, national legislation seemed compliant. This is also the case of Italy. But then, of course, you raised the Taricco question. So what if indeed on paper, the legislation is compliant with the directive, but there are cases in which one may argue that the financial interests of the European Union are not effectively protected, as it was in the Taricco case. Of course, this would be a very difficult position for the national legislature, because on the one hand, there would be formal compliance with the directive, and on the other, there would be substantive non-compliance with the treaty. And there, one way out could be, and one may think, whether actually the provision of Article 12, paragraph 1 of the directive, saying in general, the member states should ensure that the statute of limitation allows an effective prosecution, or allows the crimes to be prosecuted effectively. In that case, one may ask whether, despite the formal compliance with the threshold of statute of limitation, there would be a violation of Article 12, paragraph 1. Of course, the question is, but how do we motivate, how do we substantiate the fact that the PIF crimes are not prosecuted effectively despite the formal compliance with the directive? I don't have an answer, but this is just for reflection, and maybe something that can come up further down the line also in the case law of the Court of Justice. And I would stop here and then leave the floor to the other speakers. Thank you.
Thank you, Kathleen. I will speak in English now. Just 2 short points, and I will speak in English because I address in particular maybe the foreign colleague to provide some information. One was, let's say, provoked by Fabio's presentation before on the implementation of the PIF directive. The word corruption has not been pronounced a lot, but for me, being passionate about this issue, there is a very important provision in the directive about passive corruption of foreign officials, of third countries officials, which is an incredible step forward for the incrimination of corruption, because until now, all the legal instruments about corruption, including the OECD Convention of 1997 on foreign bribery, only obliged to incriminate active corruption of a foreign official, while providing for some flexible clauses about the incrimination of passive corruption of a foreign official. The OECD Convention, the most important instrument in this field, does not provide for an obligation to incriminate, for instance, the Turkish custom officer who has been bribed for, let's say, allowing some goods to enter the EU territory. And this is a very important added value of the directive. And these are brought Italy to fully implement, I would say, our article on international corruption, including the provision on passive corruption of a third country, a foreign official, as far as the corruption is linked to the protection of financial interest. I didn't understand if on these very specific points, all member states have been fully checked, but taking into account, and I wonder about a resolution adopted in Abu Dhabi at the United Nations meeting of the states parties to the UNCAC Convention, taking into account some discussion ongoing in the OECD context, etc., the attention paid to the so-called flip side of corruption, to the passive side of corruption, is increasing. If I say it roughly, some countries are a bit tired to pursue continuing incriminating their own citizens, their own their own companies, legal persons, etc., while there is basically no incrimination for those who solicit a bribe. So let's say that the added value of the PIF directive is going really in the same direction where, this is my impression at least, also the United Nations level, the OECD level are moving to put more and more attention on the flip side of corruption, on the passive side of corruption. Just look at the resolution, I believe is 6/8 of the UNCAC Abu Dhabi conference. Wait for the new revision of the 2009 recommendation from the OECD on international bribery, etc. So this is really to catch the move towards improved attention to the passive side of corruption. And the second point, and I just close, is was a bit solicited by also Francesca's intervention. I believe that also defense lawyers want to have more and more specialized judges in front of them on this specific side. So I think it was not mentioned today, but Article 6 of the new draft legislation, the so-called Legge Delegazione Europea 2021, which is still at the state of draft legislation, provides for concentrating the competence, which is in Italy actually dispersed on each single court, to concentrate the competence for dealing with these PIF cases in the hands of the courts in the each district of court of appeal. So this is again Article 6 of this draft legislation. Should this be adopted, I believe this will go in the direction not only to, let's say, not to oblige our deputy prosecutors, deputy European prosecutors to travel around all Italy, prosecuting all cases in the very distant courts. So this will facilitate their life for sure, but also I believe will provide the defense lawyer with, let's say, more specialized jurisdiction, which will certainly be, let's say, more structured for coping in an efficient way with this kind of cases. So this is, I believe, an interesting piece of information. I know that France, for instance, has concentrated the competence. Other countries, I believe, have done the same. In Italy, the situation at this stage is completely dispersed around all the courts, all the Italian courts, but we are moving into a different direction if this draft legislation will be adopted.
Rosaria?
Yes, thank you. I want just to make 2 points in reaction to what Fabio said. First of all, I think that common standards concerning notions of the general part will be a quite burning issues when, going to, I would say, legally applying in the field. The regulation and the national legislation dealing with PIF offenses. And in theory, I can also imagine if a legal instrument, a directive, as you were mentioning, will not be adopted, establishing common standard, this could, arrive from the Court of Justice. This is not the first, would be not the first time. Already, for example, for the notion of serious negligence, there was a position taken by the Court of Justice that has implications on national legislation. I say, for example, in the Italian system, we are talking, now we have some legal, some laws, sectorial laws, that introduce this kind of concept that was not provided in the general rules concerning the subjective concerning the mens rea. So it is possible, I don't know, for example, that at a certain point, I was making the example that, for example, in Italy, there was no consequence concerning the conspiracy with, concerning the declarative, the fraudulent declaration, etc. It can happen that in a certain circumstances, the Commission thinks that this is not a full compliance with the obligation stemming from the directive. It can bring the point, in front of the Court of Justice. It's quite theoretical from a political point of view in this moment, but it's perfectly possible then in a situation in the near future, the Court of Justice could intervene and giving a push in establishing common standards concerning also concept of the general part, because they are completely, crucial for the action of the, of the European public prosecutor. And then a second point that was, came in my mind when Fabio was mentioning the question how to solve the problem of prescription, the fact that we can have a situation of compliance, of formal compliance with provisions in the directive, but then a certain, I would say, infringement of the spirit of the treaty, of the spirit of the general obligation of an effective protection of the financial interests of the Union. I think we should always keep in mind what the ordinary legislative procedure means. The ordinary legislative procedure is a dynamic of co-legislation in a certain sense. There is, I think, on the two sides, we have responsibilities and obligations in a certain sense. So concerning the position of the EU legislature, the instrument of the directive per se needs to leave some room for the discretion of the member state, but we have to consider that a directive in criminal law has the responsibility to clearly indicate the choice of criminal policy from the EU legislator. So it's not easy. Huh? It's easy to say it in theory, but then the fact is that this description in the directive needs to be clear enough not to give too much room to the national legislator to make other kind of choice. I say overlapping choices of criminal law. On the other side, then we have responsibility of national legislature in, obviously, I would say, managing with the entire national legal order, because it's obvious that when you intervene on single provisions, you may risk not to reach the final goal. But what I want really to stress is that really is a combined responsibility. The European legislator cannot put the blame, cannot put the burden on the national legislator, because at the end of the time, at the end of the day, this is the situation. If you, use terminologies, etc., they are very open. They are not, very technical, etc. But on the other side, the internal legislator has the responsibility to implement, but fully and completely and really and effectively implement European legislation. Thank you.
Thank you very much. So, with this very interesting comments, I would also like to open the floor for questions and comments to the speakers of the panels or general reflections. There had been much food for thought on the table. And we have one more microphone on the table. So if you would like to ask a question, I would like to ask you to come to the micro. Inge.
Thank you. Very good. Yes. Yes. So good afternoon. Luca De Matteis from the legal service of the EPO. Thank you to all the speakers for these interesting insights. I had one comment to make to the presentation of Francesca Ruggeri concerning the question of allocation of jurisdiction between different concurring jurisdiction within the EPO. And on the one hand, I think that we are all clear and extremely conscious of the impact that the choice of jurisdiction will have on the rights of the defense. And from this point of view, I would like to recall that during my previous involvement in the Italian delegation for the negotiation of the regulation, we very much insisted on specifying to the largest extent possible. I'm going to give you the mic back.
I think it's nicer for you, Luca.
Can you hear me? Okay. We made an effort without the delegation to specify to the largest extent possible the indications in what is now Article 26 of the regulation, which in the Commission proposal, to be frank, had a different philosophy underlying, whereby the main parameter which was taken into consideration to allocate concretely the competence to one or the other European delegated prosecutor in case of concurrent jurisdiction was the criteria of the one better placed to carry out the investigation. What, of course, brought up a number of problems in terms of compatibility with certain fundamental rights, bearing in mind the principles stated also by the Court of Justice in Camilleri against Malta and the case law that we know. So from the point of view of the EPO, the importance and the sensitivity of this issue is clearly present. What I find should be an element that must feed into this reflection as to how this will be applied is to compare the effects of how this power of the EPO will be exercised to the situation as it is today, or as it was until the 1st of June. Because we have a situation where there may be concurrent jurisdiction in that there is competence of more than one member state to investigate and prosecute a certain PIF offense. Often in the case of complex conducts, this is natural data in that member states habitually tend to eradicate jurisdiction even for small fractions of the offense committed on the territory. And before the EPO, this situation was substantially left to the resolution of the goodwill of the authorities involved, because you would still have today concurrent jurisdictions without a mechanism, or at least a binding mechanism to resolve that conflict of jurisdiction. Granted that, for instance, Eurojust has a proven track record in this respect, but it's a purely voluntary access in terms of recommendations. And of course, you would have, as a defense lawyer in this case, to add to the burden of the defense outside your home jurisdiction, the burden of explaining to all the others why they're heading towards a bis in idem situation. The EPO does not eliminate these problems for the defense, in that indeed, as a defense lawyer, you will have to face the possibility that the person that is assisted by you will have to face prosecution and trial in a jurisdiction other than their home jurisdiction. But the EPO, based on the criteria which we assume are sufficiently clear to guide its decision in this respect, will itself take a decision of concentrating investigations and prosecutions into one jurisdiction. So from this point of view, this is an element of simplification of the system. Now, that, of course, does not change the fact that indeed, and fully aware of this, the criminal defense is going to have to give itself the instruments to become a European criminal defense, just like now we have a European prosecutor. What is not simple, and what of course requires an investment which may or may not be in the making. But the choice of jurisdiction by the EPO is an element of simplification, not of complication. One last remark I wanted to make, and here go back to historical things about Rosaria's idea of a general criminal law part, just to remind about ancient times when in 2009, the council, which was back then acting according to a whole other level of ambition with respect to the council today, approved council conclusions on model criminal provisions guiding future instruments of criminal law, in which it tried with extreme difficulty and with extremely modest results, but the scope of the exercise was not in itself meant to produce a full body of law, exactly to go into this type of reflection and to give some indications as to what it means to have an attempt, what it means to have intent. And how crucial these questions are one of the last discussions we had in the EPO concerned the question of intent in relation to fraud offenses in Article 3 of the PIF Directive. In particular, the different ways of understanding the question of direction of the intent, which is requested by Article 3.2, and how this is differently reflected in national legislation, but also in national practice and understanding of criminal law in terms of how intent should actually be structured. So from this point of view, yes, indeed, this is a crucial thing. But again, as you all have indicated, I do not see in the immediate future the ambition to go that far. Thank you.
Thank you very much, Luca. I suggest that we collect the reflections and the remarks, and I will give then the floor to the speakers to close the session. So the microphone is now at the corner. I think there is a disinfection coming to be COVID compliant.
È acceso? Sì, benissimo. Allora, Ignazio Patrone della
I am
Fondazione
Ignazio
Basso,
Patrone from the Fondazione Basso, and I am retired member of the Judiciary. I listened to what Luca just said. I understand about the good intentions of the PPO, but I believe that there are some difficulties. Number one, decision over jurisdiction is up to the judges, not to prosecutors. So you could have a judge who could say, you carried out this prosecution, but I am not competent. And I am not competent on the basis of national laws, which in the case of Italy have constitutional value, because the principle of the natural judge is one of the pillars of our criminal procedures. This is not the case in every country or for every offense, but I know that it is the case also in other countries. So the problem may arise. What would happen if hypothetically I'm using my imagination, but even not too much. We have 50 defendants because we're dealing with a very complex cross-border crime that was carried out thanks to the actions of many individuals in many countries for many years. Let us think of a systematic smuggling network, products which are produced in a given country where the customs is more favorable. They are declared in that country, but in fact, they are produced elsewhere where the customs rules are different. At that point, we go to the judge with a lot of documentation, and the judge is going to say, yes, but this is a minimum part of what the prosecution is doing, whereas there's a bigger picture that I cannot judge upon, but you're asking me to judge upon it all. So on the basis of Italian legislation, I declare myself as not competent. Then we go to the French judge or the Belgian judge, and the judge rules in the same direction. This may happen. I'm not being too creative by imagining a situation where the judge declares herself as not competent, because I mean these trials aren't exactly easy. Judges aren't necessarily sort of rushing to be the ones working on it. You're not going to become famous thanks to them. You're going to spend years working on following a very complicated trial. Your office is perhaps already burdened with a lot of work. what will happen in this scenario. Something that was not considered was the possibility of a supranational judicial authority with the power to decide in those cases. I made my very humble proposal back at the time to the group of experts of the Commission, because it would have been wise to identify a mechanism where you had a judicial authority for such cases. You could have used the rule that allows to create special judging sessions at the first grade. Now, because, and also let's consider the real situation. You need to defend yourself in a different language, a language which isn't yours, in a country you are not familiar with. This means that you're going to need to hire a lawyer in that country. You will have to have a lot of documents translated, because yes, the translation directive says that you will have a right to have translated documentation, but not exactly everything is going to be translated. I was the liaison prosecutor in France for 2 years. Now, if I were either the defendant or the defense lawyer, I would have been petrified, and at the cases that I witnessed, and they were pretty easy cases, but the methodology was completely different with respect to our methodology. It was faster, it was more efficient, unquestionable, so easier for certain aspects. But I would have panicked if I were an Italian defense lawyer or an Italian defendant in one of those trials. Now, I hope that this scenario will never happen. But perhaps the discipline should have paid more attention on the problem of jurisdiction, on the fact that that is decided upon by judges, and it only covered competence when it comes to prosecution, and it has done a good job in regulating that part, because as Lorenzo was saying, yes, and we did an important job at the negotiating level to make sure that at least that aspect was covered, but maybe more should have been done. Thank you.
Thank you very much, Ignazio. You see that there are interventions from participants. the last for the best.
Is it already on? Yeah. I actually didn't want to talk about this. I wanted to talk about the conflict of interest, but your intervention, Ignazio, really triggered me, right? Well, yeah, I have to talk closer. Right? Article 26, paragraph 4, I guess. Everything is there when we talk about, I wouldn't talk about jurisdiction here. I wouldn't use this word here ever, but competence of the prosecutor, which is quite different, right? Why that? Jurisdiction belongs to the judge. You said it rightly. It's exactly like that. Competence belongs to the prosecution, basically, right? Here, in this case, I'm talking about Article 26 of the regulation. Article 26 of the regulation states that the PPO will decide based on some criteria that I'm not to talk about now. What is the European delegated prosecutor from which member state that will handle the investigation in a state that has jurisdiction? This is a precondition that comes before anything else. I mean, would we go and give the case to an ADP in a state, in a member state that has no jurisdiction? That would be a suicide. I mean, of course, the first judge that comes into place says, Not I'm not competent, I have no jurisdiction. So please get lost, and rightly so. I mean, this is crazy. Problem, what is the real problem? I'm going to talk about this tomorrow a little bit, okay? Is that Article 26, and with the logic behind that, with the rationale, favors the creation of a single investigation. Not like now that we have carousel frauds that involve 20 member states with 20 different investigations, but maybe 40. Because, for example, in Italy, it is not rare that the same carousel fraud is investigated by 4 or 5 different offices, because the missing trader is here, and the user, the final user is here, and the other shell company is there. It's always like that. We've been prosecutors, we are prosecutors, and we've seen all these cases, right? But so the favor is to have one single case with the PPO in a member state that has jurisdiction. Are there more than one member state that have jurisdiction? Yes, it's possible. It's absolutely possible. That's in the logic of the regulation. So in that case, we have to pick one, which is the main prosecutor, and the other prosecutors in the other member states become assisting prosecutors in accordance with Article 31, which is another big topic that today was not touched upon, okay? So what happens there is that we have the criteria, is where the focus of the criminal activity, where most of the criminal offenses have been committed, and so on and so forth. There are a few criteria. And if it's not enough, we have Eurojust guidelines to follow as like an additional guideline if needs be. We are not there at the moment, right? We started only, we've been operational for 4 months only. We are not in that situation, but we are in a very different situation that I think is completely out of the regulation of what the lawmaker was thinking about. We are bumping into cases where it's the same organized criminal group, it's the same criminal activity, it's the same fraud, custom fraud, smuggling, VAT fraud, and there is no jurisdiction in all the member states. There is no jurisdiction in some of the member states that are involved. They have jurisdiction only for a part of the conduct, not for all of it. In that case, we have no other choice than opening different cases. We cannot create a single case, because the first time you go to the judge in Belgium, it would say, I have jurisdiction only for this part of the conduct. And we don't want to lose the other. So we open a case also in the Netherlands, also in Germany, also in Italy. And we have 4 cases. So the 4 ADPs sit around the table and coordinate. And there's no other way out. We have to respect the rule on jurisdiction. We have no choice, no option when it's like that. We have option only if the jurisdiction belongs to all the judges of the different member states. Then we have an option. Otherwise, it's like that. So we are very conscious of this, very, very conscious, and it's part of our operational life every day. The permanent chambers every day discuss these kind of things, right? So, I mean, just be assured that it's on the table. Going back to the issue that Fabio and Lorenzo discussed of the possibility of the entitlement of a general prosecutor's office, let's call it that, for the sake of clarity, to refer a case to the court. Well, Fabio, we have our hands tied, because Article 25(6) states that the authority competent to resolve what we in Italy call contrasts of competence, because it's 2 prosecutors' offices, not judges. So it's contrast. Is the authority competent to resolve the same kind of contrast at national level? We cannot make it up. It has to be the prosecutor general. It's already like that, Article 54 of the Criminal Procedure Code, and the same attribution is given when it comes to this new kind of contrasts. So let's say the implementing law, I shouldn't call it like that, but the law that somehow gives effect to the regulation, to the EPO regulation in Italy, as we all know, is Decree number 9, okay, of this year, 2021. There was quite a discussion in the previous months about this provision. The Prosecutor General was involved. I was consulted. All the experts that were involved in the negotiations were consulted. And there were options. There were options, and the only other option was to give the possibility to the Prosecutor General to refer the case to the Court of Cassation just for raising the preliminary question with the Court of Justice. In the end, it was decided not to do that because the office, the Prosecutor General, and I totally agree with them, is convinced that in Italy, the Prosecutor General, in this case, takes action inter partes, right? Which did not happen in the case of Trento Prosecutor's Office, right? And when I read that case, I said, how can they do that? It's not inter partes. And then I read the opinion of the General Advocate that supported them and says, well, this is impossible. And then the judgment came out as, of course, it's not inter partes, but this is inter partes. This is absolutely inter partes. And if we want to give an effect util to Article 25(6), that already gives that kind of competence to that kind of office, we need to recognize this power to the General Prosecutor's Office. I think it also fits with all the criteria that the Court of Justice established to have that kind of authority. So we'll see, but that would be quite absurd to give that power only to the Prosecutor General Office because Article 25 says so, and then tell them, well, I'm sorry, you cannot go to the Court of Justice.
Inge, you want to? Yes, Inge, Hans-Holger. Let me just see if there are anybody else who would still like to intervene. Then we have 2 more interventions, and then I will give the floor to the panel. So Inge, please come to the microphone.
Is it on? Yes? Can you hear me? Okay. Now, first of all, apologies for my coughing. It has nothing to do with COVID. I'm vaccinated twice, I'm tested negative, and even in COVID times, there's still the old boring cold. Right, now having said that, coming to the topic of the last session, the PIF directive and its implementation. I will probably refer to the first presentation on the offenses as set out in the PIF directive. We all know that the competence of the EPO is linked to the offenses set out in the PIF directive. So the question whether the EPO has competence and can exercise its competence is linked to the question, is something a behavior, is that covered by the PIF directive or not? Now, we heard the VAT fraud presentation, and I think we all agree that VAT fraud is something quite difficult, quite cumbersome to investigate. However, looking actually at the constituent elements that the PIF directive sets out for VAT fraud, I thought it was fairly straightforward and fairly clear. However, when applied in practice, I can tell you it's not. So actually, recently, we had to reply to a question on the basis, I will probably best start with a practical case. We had to answer the question, Lorenzo, come on. You should focus on what I'm saying. Now, and I apologize already now because I have to dig a little bit into tax law. Obviously, VAT fraud is tax related. The question that we had to reply to on the occasion of the decision as to whether EPO has competence and should exercise its competence was the following. We had a case where, let's assume it was one perpetrator, imported goods into the EU, into country A, and underdeclared the goods with a too low value. Now, first of all, that means evasion of customs duties, but secondly, that also means evasion of import VAT. Now, the same perpetrator applied the same scheme under declaration of the same type of goods when importing the goods into country B, right? So the question was, is that covered by the offense of VAT fraud as described by the PIF directive? Actually, what we have is in the PIF directive, serious offenses against the common VAT system. They need to be committed in cross-border fraudulent schemes, and they need to be connected to the territory of 2 or more member states. And then obviously the total value has to be above 10 million euros. And actually we had a damage of import VAT in country A of 8 million euros and in country B of 4 million euros. So if you add the damages, you would be above 10 million euros. So is that covered by the PIF directive or not? We discussed the question in the college. We have come to a conclusion, but this is food for thought for you. I mean, whatever looks so straightforward and so simple can be actually quite tricky when applied in practice. And should there be anyone here in this room who is a witness of the negotiations of the PIF directive, he or she will probably be a he. The other he is here. You may also wish to shed some light on this question. What may help, sorry, 2 hands are often not enough. What may help as well is, recital 4 of the PIF directive, which says, the notion of serious offenses against the common system of value-added tax, as established by Council Directive 2006/112 EC, that common VAT system, refers to the most serious forms of VAT fraud, in particular carousel fraud, VAT fraud through missing traders, and VAT fraud committed within a criminal organization, and so on and so forth. So it says, in particular, which usually means that other forms of VAT fraud should be included as well. It's not necessarily limited to carousel fraud. And I can also tell you, we've verified, there is quite some jurisprudence of the Court of Justice saying that import VAT is covered by the common VAT system, by that directive. Was that the intention of the EU legislator? Question mark. Food for thought.
Thank you very much, Inga. I think that colleagues around the table are already thinking, but I would like to give the floor for the last question to Hans-Holger Hanfeld.
Press the button. Can you hear me? Okay. My name is Hans-Holger Hanfeld. I used to say I'm from Germany, which was true. I was working in the Ministry of Justice there, dealing with the EPO negotiations. Now I'm a retiree living in Vienna. So I'm no longer saying that I'm from Germany. There are a lot of interesting things have been said. There's one thing I want to dwell on a little bit and pose a question to the podium. The question of Article 26 is one aspect of it. If you have more than one member state that has jurisdiction, and as Danilo rightly pointed out, of course, you come to Article 26 only if there are member states that have has jurisdiction. As you know, the recital 87 or 88 says that member states shall, at the latest in the trial stage, allow for judicial review of the decision to have an EDP in charge. The interesting question will be how member states implement that. because indeed it is not the question of whether the court has jurisdiction, because you have 2 or more members that have jurisdiction. So you have to do more than simply allow the judge to decide on whether he or she has jurisdiction. What we did in Germany is we included an additional provision in the Criminal Code of Procedure saying that the suspect can challenge the EPO's decision to bring the case to Germany. So he does not challenge that Germany has jurisdiction, but the challenge that the EPO brings the case to the German court. I don't know whether other member states will have similar. I know in Austria it is similar, but I don't know whether other member states will do the same thing. That is one point, though. What I think will be interesting in the future is to see whether even during the investigations, the issue can be brought to the attention of a court by a suspect that the EPO is actually investigating the case in the wrong member state. That can certainly happen in the case that you need an arrest warrant and have a person surrendered from member state A to B. Then maybe the suspect can challenge the decision to even do the investigation in member state A, because he would say, well, I committed my crime in member state B, my home state, not in member state A, where the EPO believes that the focus of the crime was. And then maybe the member state B can decide not to surrender the person to member state A, in spite of the fact that the EPO had decided that that is where the focus of the crime is, and that is therefore where the EDP is in charge. But the question is whether also other points, like asking for a telephone interception or a house search, whether the suspect can then challenge the internal competence of the EPO. And that, of course, we will have to see. Which brings me, though, to another aspect of it. Lorenzo earlier addressed Article 25, paragraph 2 and 3, the division of competences between national authorities and the EPO. Here again, the question is, can the suspect challenge the EPO's decision to investigate on the basis that under Article 25, paragraph 2, the suspect believes that the EPO should not exercise the competence, but it should be a national authority. And it would be interesting for me to hear from you whether you believe that there will be possibilities for suspects to challenge that. And finally, since Ingrid asked whether somebody is here who was participating in the negotiations, on your question, Ingrid, 2 points. First of all, I think in principle, yes, income VAT, so import VAT is just any other VAT, so it could be possible. However, I don't believe that it is possible to say the criteria of 2 member states is fulfilled if there are 2 different acts, one involving one member state and the other involving another member state. I mean, if you have a suspect doing a VAT non-declaration in respect of an import or export in respect of one member state, then it is clearly not a VAT fraud and clearly not a PIF fraud, because it's only one member state. And if he then does the same thing again 3 days later with another member state, you cannot say retroactively now the first offense becomes a PIF offense, because it is now 2 member states where he does the same thing. So I don't see how you can simply on the fact that the person commits 2 different crimes come to that conclusion. It may be different if both are actually part of the same crime, then maybe that is a different issue. But if it is 2 different crimes, I would say it's clearly not a PIF offense. Thank you.
So a lot of food for thought. I would like to give the floor for a closing remark from each member of our panel in the start of the presentation. So first to Fabio, there was a lot of comments to the Commission. So I leave the choice to you, which one you pick up.
Thank you, Katalin. I don't think I will have the time to address all the issues that have been raised. I took 4 pages of notes, so it will take too much time. Maybe just a few issues. Probably the first one being again on the position of the defense, which has been addressed before. I think it is clear that the defense will have some challenges. I do agree with the point that was raised by Luca, is not that the EPO has created the challenges. Now the challenges were there. And that's the reason why there have been some directives on defense rights. Of course, I do understand the point that these problems now have a different, so to say, declination, if you want to call it that way, because we are in the context of a single office. And of course, I mean, we will have, in any case, to review the regulation, say the regulation in 5 years' time, to check how it has been working in practice. So if there is something to be addressed on the defense side, it might also be the case there. And in any case, the proposal by the Commission was slightly more ambitious in that respect as well. So it might be something on which we will come back anyway. Yes, the other issue on the conflicts of competence, which was raised by Danilo Ceccarelli, indeed, I know it is there. I also think, and I think we can agree on that the regulation says a lot, says, as we would say in Italian, everything and the contrary of everything. So that's what we have to do. And I also want to say that some member states, precisely because of some ambiguity of the regulation, clearly decided to go against the national law, so to say. So to depart for EPPO cases from the rules on the conflicts, on the contrast of competence, just to give it to an authority, a judicial authority stricto sensu, so to say. So there are ways. When there's a will, there's a way. We will see whether there is the will. But of course, this is something that, again, also here the practice of the EPPO will help us to understand whether and to what extent this is a problem and how it could be solved. And then I think the last point was raised on VAT. I do understand it was food for thought, so you don't expect a clear or yes or no answer. I would tend to say yes in both of the cases. That would be my reading of the regulation, but pardon, of the directive. But of course, I do see that things can be more complicated in practice than in theory, and that's again why I say, of course, the screening that we've done so far is compliance on the basis of the law, but then there could be cases in the future of bad application of national law. So if there are these cases, of course, we would be willing to look into that. Yes, and maybe last but not least, the judicial authority at the European level, which was also mentioned before on the conflicts of jurisdiction. We were discussing with Rosaria back in 2000. This was discussed in the Corpus Juris, and the European Pretrial Chamber and never fly. We'll see whether it will fly again, this idea, but let me say it looks a bit unrealistic for the time moment, but we shall see. Thank you very much.
Yeah, I mean, I would like to give the floor to all of you if you want to add something for the comments. If not, that's also a choice.
Just to reply, because there was a direct question from Ansorga, I understand. If I understood well, yes, I think that from the defense point of view, if you have doubts about the competence of the EPPO because of the damage, of the value of the damage or whatever else, in Italy, you would certainly be entitled to, even if the prosecutor, national prosecutor, does not. The defense lawyer can raise the question, because this is about the legality of the procedure. So I don't know if my colleague agree, but for sure that there is, under the Italian law, there would be an opportunity to challenge the competence also of the EPPO under the provisions of the regulation. And with the possibility to also for preliminary ruling to the Court of Justice, for sure.
Thank you. I looked at Rosaria, who does not want to take the floor anymore. I don't know, Francesca?
No, io solo una parola, ma semplicemente...
Just a couple of words, if I may, in light of what was said about the defense rights. There is a problem which was the center of my reflection, at the center of my reflection. It's the defense role is not a public function, so it's difficult to get organized and more complicated to organize the rights and the freedom of the defense. As you know, there are several initiatives that have come into being on the right of the defense. In Germany, the point was made about the possibility of establishing an office that would give access to those that are the defaced. The problem that is with that is that it's an individual person, so it's more difficult to organize the rights of the defense.
Thank you, first of all, to the audience for the patience and the very lively discussion and bearing us until this late hour. I would like to invite you to applaud the panel, which gave a fantastic presentation and a fantastic discussion. I take the opportunity to thank to the Fondazione Basso for all the organizational efforts. I think that there is a dinner ahead for the speakers, and with this we close today's conference, and we are looking forward to seeing you tomorrow.